everyone, Harry here to talk about Donald Trump's very broad fishing expeditions and the insights they give us into how he's going to try to defend in the January 6th related charges before Judge Tanya Chutkan. All right, two separate and fairly big developments today. The first is a denial of a motion from Trump that he filed about a month ago from Judge Chutkan and her 7-page order explaining why. But what he tried to do here was issue a subpoena under Rule 17 to non-parties. So there's a special device that you can say, I want to, subpoena this member of Congress or this committee or this hot dog vendor if they have relevant, admissible evidence. It is not supposed to be a substitute for the discovery process of dealing with the United States and getting stuff from them, your actual adversary. It's a separate device from third parties. All right. So what matters initially is what he was looking to do. And basically, he was looking to get information from a lot of separate folks about the January 6th proceedings, which he says have holes in them. That's actually a separate dispute. Between, of course, the Republicans and Democrats as to whether things were all archived when the Republicans, unceremoniously kicked the Democrats out of their offices and took over the committee. But Trump has asked for videotapes and transcripts and other materials that he says are incomplete in what he has so far from the January 6th committee. And in an order yesterday, Judge Chutkan denied. So let me explain that to you a little. First, he identifies the materials. He wants certain records. He wants transcripts. He wants videos. And under that subpoena rule I told you about, you can subpoena third parties, but you've got to be able to show that it's not just a substitute. It's not supposed to be a fishing expedition, and it's not supposed to be a substitute for other discovery devices. You've got to show the evidence would be relevant, would be admissible, and you've got to specify pretty well what it is. Those are not, by the way, even taken together, particularly high hurdles. But Chutkan said that Trump didn't satisfy them here as to different kinds of materials. First, all this missing material stuff that he says just isn't in part of the transmission that the committee made to the executive branch. She just says, well, no, according to the very letters that Trump has, the select committee didn't send that material over. So you fail to show that it's actually available. Then there are these written interview transcripts that the government got from certain, from the select committee. But she says, look, you can get those by discovery from the government. So the subpoena is not necessary. And then finally, the video recordings, she says, those are all, by the way, hearsay. We'll probably deal with them at another date, but they can be used for impeachment of witnesses. But she says that's just doesn't make it sufficient showing of relevancy, because you can impeach with the transcripts themselves. You don't need the videos. Plus, we don't know that it's going to be valid impeachment material and the like. So she goes through each of his requested categories and denies them for different reasons. That is important in and of itself, but also it shows how, the Trump is trying to cast far and wide, especially for any evidence, by supporters or the cut in the other direction from which he can try to show, he genuinely believed the election was lost or whatever might have been investigated by the committee. And that brings us to the other big development, which is a motion that Trump filed yesterday. And it also, I think, reveals his hand. It's pretty interesting. He is seeking, again, a very broad swath of material from the executive branch. So the executive branch, he identifies all kinds of agencies like Department of Homeland Security and the Secret Service, all kinds of folks. So that's first. The same kind of thing, casting far and wide. And for what? Any evidence that might suggest that he thought genuinely the election was rigged. That makes this motion technically a Brady motion, and Brady is the area of law named after, I think, the 1964 Supreme Court case that says if the government has in its possession any evidence that tends to exculpate the defendant or is very important for the defendant's case in chief, they must give it over. Failure to do so is a very serious due process offense, a violation of the due process clause, and an easy, quick route to reversal. So he's saying, I want this stuff under Brady. So that's point one. He is again putting in play the notion that the election was rigged, or he believed it was rigged. He's, doubling down, except we're not doubling now. Where are we? 256 or 512 or 1024? I need to ask my mathematician kids, but we're on some high power of 2, saying the election was rigged, or maybe trying to say he genuinely believed it was. But the actual motion, this sort of pivot point of it, comes out in the very first sentence, which he says, I want an order to identify the, quote, scope of the prosecution team. What's that mean? That is another clue that this is a Brady motion. Under Brady, the government doesn't have to go hunting far and wide in the files of the entire executive branch, which would be impossible. If you later turns up in Department of Homeland Security some snippet of exculpatory material, that doesn't mean there's a Brady violation. They've got to, it's rather the scope of the prosecution team that determines the scope of Brady obligations. So you can be sure that this is a Brady motion. He's saying, give me all this because it might be exculpatory. And he's naming all these folks who you wouldn't think are part of the prosecution team, but he wants to make an argument that they are. And, so that'll be litigation. Is this, did the government at all deal with DHS? Does that make them part of the prosecution team under the law for when government has to produce Brady material? So that's what's going on. And one other point, he is asking in the motion to file exhibits and the motion itself, an unredacted copy, under seal. So he's further saying that I don't want the government to be able to see my Brady motion because it would reveal my hand of my defense. And so I want to submit this only to the court, but I want the court to hold that the scope of the prosecution team is wide and that all these things have to be given over, but I don't want them to see any argument for why they must be given over. Okay, so we will see how Chutkan deals with that. I think it's pretty weak, but there are cases that go. There are some cases that go strongly against the government where you have individual judges holding. That's part of the prosecution team. The better cases, don't because that would in effect mean that the government has to do fishing expeditions all through the executive branch. So we'll see what she does with the actual motion, but it does give an indication that, among other things, he's going to try to just cast a very wide net to try to prove that, maybe he thought it was rigged, because that's what would be the Brady material. And that's one final point. They're looking ahead to this trial because how is Trump, we've talked about this for a while, but this really brings it home in a nice way. How is Trump going to try, if it's his defense, to say, oh, I really believed it? the way to do that, maybe the only way to do that, is by testifying. But Trump can't testify, I've said before. Just not in a criminal trial. He'll be totally dismembered by Jack Smith's team and expose himself to perjury. I don't think it will happen. So he's got to be thinking hard about other ways of getting in exculpatory material. Those will, that say, oh, Trump told me that he thought it was really rigged, or little snippets like that. Of course, they themselves will pose their own evidentiary hurdles and admissibility hurdles, largely hearsay. We can explore that, plumb the depths of it more when they actually come up. But the final point that this interesting motion illuminates is how Trump is going to try to prove this old canard, to give some reasonable doubt to a juror that maybe the election either was rigged or he really thought it was. How to prove something like that when you're a defendant who doesn't want to testify. So that's the third really interesting point that's now put in play. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.